Welcome to the Sacramento Injury Law Podcast.
Welcome to the Sacramento Injury Law Podcast. I'm your host, Lisa Mosby, and today we're joined by Brian Jacobson from Aiken and Jacobson. With decades of experience fighting for the injured across Northern California, Brian and Lee are here to let you know how California insurance companies are evaluating personal injury claims in 2026. Welcome, Brian. Thanks for being with me today.
Howdy. How are you?
I'm well, thank you. In 2026, how are insurance companies evaluating pain and suffering when it comes to damages in personal injury cases?
They're still using the computer programs. It started probably 15 years ago with a computer called Colossus, and I think it's just been upgraded now with different variations, obviously with the AI, where they just plug in different settlements, different attorneys, just as much information as they can get, various settlements, that sort of thing, to try and hone in and come up with a general number of what people are settling it for each case I should say.
And I don't think the general public really knows about that. I had never heard about that before. So can computer programs realistically calculate a human being's pain and suffering?
Not if you ask me, but that's certainly what they're using. That's part of the problem that the plaintiff attorney has to argue about. They would like to make it just a bottom line number. I think each person's pain and suffering is different, and I think any plaintiff attorney would tell you the same thing. But that's certainly what we run up against. Is they want to make it super easy so that an adjuster just looks at a number, punches in a bunch of numbers, and comes up with no feeling, no emotion at all, and that's what they're going to spit out and tell you that's what the case is worth.
And California insurers must now disclose policy limits within 20 days. How does knowing the policy ceiling immediately change how you evaluate an insurance company's first offer?
They do, as long as they have to have their insured's approval. But if they do, it helps us to better recognize whether it's a legitimate offer or not. A lot of times we're still getting, lowball offers. The other trick that they're doing now is making an initial offer prior to an attorney getting involved. Once the client gets in the accident, within a couple of weeks, they'll get an initial offer, $2,000, $3,000, $4,000, $5,000, in an effort to try and make the case go away. What I tell my clients is be very careful, because a lot of times the injury doesn't show up at that point. They don't know a lot, and if you settle your case at that time, the case is over. A lot of people don't understand that. It's certainly not explained to them. They don't understand that if they do settle it for that, they don't understand a lot of times that also means that money is used to have to pay back their medical providers. The insurance companies don't do a very good job of explaining that to them. So there's a lot of confusion with the insurance companies and the way that they make their offers. And so a lot of times it's just a confusing process.
And since California's minimum liability limits jumped to $30,000 and $60,000 this year, are you seeing adjusters fight harder to keep those settlements below the new higher floors?
Yes, the adjusters tend to still treat it like it's a 1530 state. They still recognize it's a 3060 limit, but they're doing like you say, they're doing everything they can to still keep it under the 1530 limits, almost like it's their own money that they're trying to save. But that's just natural. They're doing everything they can. The insurance companies do everything they can to save as much money as they can. That's just a natural thing that's been going on for years.
The way it is, yeah.
The way it is.
What happens to a claim's value if a doctor uses a slightly wrong term, or how do you catch those mistakes in the paperwork?
Well, certainly if the doctor uses the wrong term or code, the value of the case goes down, because again, that's what the insurance companies are evaluating claims based on. Is that goes back to what we discussed earlier, the computer program. The adjusters don't use much of their own skill anymore, I guess I would say. It's all based on they input the codes that the doctors use into the computer program. The computer program then spits out what a reasonable time of treatment would be, what a reasonable cost for that treatment would be, and spits out a number of what the value of that case would be. Put in a wrong code, whether it's entered wrong or whether the doctor enters the wrong code, is going to decrease the value of the case. Part of what we do, I've been doing this 35 years. My partner's been doing it for over 45 years. We're going to check all those codes before we put together a settlement letter that goes out to the insurance company. We're going to double check it, make sure that none of the codes are wrong. We've been doing this long enough to know exactly what the code should be. We catch, any mistakes that the doctors would make. Not that they make any, but if there are any, we will catch them before they are made.
It's a very mathematical process now. There's nuances, I'm sure, but it's
Yes.
laid out pretty clearly.
Yes.
How much weight do the 2026 adjusters place on a claimant's like Instagram, TikTok, social media posts compared to the actual medical evidence of their injuries?
It can be quite a bit. That's one of the things that we educate our clients on, or try to educate our clients on from the very beginning, is be very careful what you post on your social media. One of the things that gets people in trouble is, especially nowadays, is everybody wants to post everything on social media. So adjusters will use that because, again, they're going to use every tool that they have, and they will comb social media to see if you posted, "Hey, I've got a back problem, but boy, I was out lifting stuff the following day," or doing something that you said you couldn't do. So if it's on your social media, chances are they will find it. We do in lawsuits, we have things called discovery, which is sort of an investigation process. They will ask for all your social media posts. So you have to be very careful. If you're in an accident and you post something on social media, more than likely it will be found out by the insurance company. So they place quite a high premium on information that's in your social media, whether it's pictures, whether it's posts, whatever it is. You have to be very careful.
We don't have any secrets anymore.
No secrets. There are no secrets anywhere.
How often do insurance evaluators use a person's old medical history, like maybe a minor back strain from years ago or a serious accident that maybe didn't cause real accident or real injury at that time?
Anytime it can help them. If it goes against them, they won't say a word, but anytime they can help them, it will be used against them. Again, they will hire doctors to say that if you are having the same type of complaints in a current accident, that they're going to try and use your old complaints against you. If you're having the same type of, if it was the same type of an injury, again, that injury was probably made worse by the current accident. At least that's what their doctor's going to tell you. Again, there are counters to that. The counter is time. If there was no treatment, one of the things that we would say from our side is if there was a long period where you didn't get treatment for, let's say you had an old back injury, but you had worked diligently without any issues to your back, that goes against anything being related to a prior back injury. So there are ways around it, but you have to have a good attorney to fight on your behalf to use those methods to get you out of that argument.
And I've heard stories. If a victim's doctor says that they'll need surgery in the future, why do insurance companies often try to value the future need at zero during the early negotiations?
Insurance companies are very skeptical. They don't believe that if it hasn't been performed, that it won't be performed. They tend to believe the longer the time goes on, the less likely it'll occur. So if it's something that's been dragged out for a year or more and it hasn't happened, again, that makes it harder. If it's relatively new, it's a tougher argument for insurance companies. But again, it's an argument that can be argued against with a good attorney, but there are some variables to it. Time is the biggest issue. If a client's waited 2 or 3 or 4 years and hasn't had something done, that's going to make it a tougher issue to get over from the plaintiff side.
And this one's more of an industry question. If it's a known secret that insurance companies track which law firms actually go to trial, how does your firm's reputation for litigation affect the computer-generated offer a client receives?
Well, I mean, we do go to trial, so it only affects it in the sense of they will not ding us for not having gone to trial, because both Lee and I have tried cases before. So they will ding you to a degree if you are not willing to go to trial, but we haven't seen it affect our cases, so I can't speak to it affecting us. But that, again, that is a variable that the computer generated stuff that the insurance company use. That is one thing that they do use.
And I only bring that up to let people know that it's important how they choose the attorney that they work with. Can you make some suggestions or recommendations on questions that people should ask, or that interview process when they're searching for the right attorney for them?
Yeah, and it's the same thing I tell all my clients is you have to be comfortable with your attorney. You have to, for my clients, I tell them it's anywhere from a 6-month to a year or more process of being together. You have to be comfortable with your attorney. I tell my clients that if you call me, I'm going to get back to you within 24 hours. If you are, not getting, we don't have paralegals or people that we work with. So when you call, you get me. If you can't get a hold of your attorney, that's probably not someone you're going to want. I'm usually very good about getting back with people, whether it's I have a cell phone that I have attached to my hip. You can call me on my cell phone. You can email me. You can text me. I'm very easy to get a hold of. You can contact me on the weekends if that's, I'd rather have you contact me on the weekends than sit around and worry for the whole weekend. But you need to be able to get a hold of the person that you're in contact with, because again, this is a very traumatic time that the person's had to go through. I think we talked earlier, chances are this person has never been through this before, so they don't know what to expect. Like I said, I've been doing this 35 years. I know the process. I'm happy to explain it. I enjoy doing my work. I enjoy having done this for 35 years. I enjoy doing this. So I'm happy to explain it to them. They need to find somebody they're comfortable with and they can get along with. It's not a quick process. This is a process going to take some time. It's going to take them whatever it takes for them to get the treatment they need, which can be anywhere from 6 months to a year. Once that's done, it's going to take another couple of months to get the records together, hopefully get the case settled. If not, ultimately it has to go to trial. You need to ask, is your attorney willing to go to trial? Is he willing to go to the mat for you to get what you need? Those are all questions that need to be asked in the initial interview. If you have any reservations when you talk to your attorney, then he or she is probably not the right attorney for you. And to me, that would be a red flag when you're speaking with your attorneys.
And I think that's a perfect wrap up for this episode. Thank you for your commitment to your clients and to the industry and to making sure things get done in a fair way. All right, audience, thank you so much for listening to the Sacramento Injury Law Podcast. If you found this episode helpful, please like, share, and comment. Others will find this information a helpful resource. If you have any questions about your own case or need expert advice following an accident, please visit Brian at aikenjacobsonlaw.com to schedule a consultation. And we'll see you at the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.